Okay, looks like we have council connected. Sorry for the delay there. Had a little technical issue, but we are ready to get started. So we'll go on the record. This is People versus James Ruttkamp. This is Crawford County case 2411684-AR. If I could have council put your appearances on the record, please.
Yes, Dana Chady on behalf of the people.
Thank you, Your Honor. Richard Church representing Mr. Ruttkamp. He is logged in today, but again, I don't think he's a necessary party today.
Okay, and I do see that he is connected from your office. This is the date and time set for oral argument on an appeal filed by the defendant, Mr. Ruttkamp. I did have a chance to review your brief, Mr. Trush, outlining the basis for appeal, as well as Ms. Chady, the people's response to that. And so, Mr. Trush, is there anything that you wanted to present by way of oral argument today?
There is, Your Honor. I think there's a couple things that bear sort of fleshing out here. And some of it's going to be responsive to the prosecutor's brief. But I mean, to start with, we have a situation where there's sort of some complicated factual background history, and I think it's laid out by both the prosecutor and myself. The part that I want to highlight to the court is we had a young child witness. There were two trials that took place in regards with this witness potentially testifying. So one in regards to the mother, one in regards to the father. The mother's trial was the earliest of the trials. During that trial, the child witness was screened for whether or not they would be a competent witness. They were deemed not competent to testify and were not permitted to testify at the first trial in regards to mother based on that. In the second trial, he was again sought to be brought as a witness. In this trial, he was qualified. He was determined to understand the difference between a truth and a lie and all of those things. I think that's an important distinction to make, because the basis for excluding his testimony was solely on the idea that that testimony was cumulative. So I think that's important background information to understand in regards to the context of the case. With that in mind, I think one of the parts that I want to highlight from the prosecutor's brief in their argument. So the prosecutor starts out in their law and argument section, and they identify that they are permitted to argue basically the logical extensions of the evidence that's permitted. And I think this is responsive to my argument, and I think it's undisputed and it's clear in the transcript. The prosecutor elicited testimony from several witnesses that at a minimum suggested, on the other end of the spectrum, outright said that the child witness was coached, or they believed the child witness was coached. I agree with the prosecutor insofar as I think they are permitted to argue the logical extension of that testimony. But that's really where the problem is created in this case. I think they're allowed to argue the logical extension of that. The problem gets created when we bring a witness who's qualified and a competent witness to rebut that testimony, and we're told we're not permitted to do so because it's cumulative. And that's where I think the constitutional defect is here. The defendant has a constitutionally recognized right to present a full defense. In this case, it was argued, argued by the prosecutor as a logical extension of the evidence admitted, that this witness was coached. Now, here's the problematic thing, right? The court has the discretion to exclude cumulative evidence. So here's really the question. First, what is cumulative evidence, and is this cumulative evidence? And I think the answer is no. So the court defines cumulative evidence in McDonald versus Stroh Brewing Company. This is 191 Mich. App 601. It's a 1991 case. Cumulative evidence is evidence that's entirely consistent with the testimony of several prior witnesses. That's simply not the situation that we have here. The testimony of this witness would not be consistent with that of other witnesses, and specifically, it wouldn't be consistent with that on the issue of coaching. So, you know, the prosecutor argued ultimately in the alternative, one, that an assault never happened, or two, that if an assault happened, it didn't happen in the way that my client described it. The cumulative element of this, or why this isn't cumulative, is once she opens the door and alleges that this witness has been effectively tampered with or his testimony has been coached, his testimony is not cumulative as to that issue. It's not cumulative at that point. I don't think it's cumulative as to the other issues as well, but it's certainly not cumulative as to whether or not he was coached. The courts go on to talk about cumulative evidence in further case law. So this is People versus Norwood. This is 123 Mich. App 287. This is a 1983 case. Cumulative evidence which rebuts the prosecutor's case should be admissible if it assists the defense. The court there went on to find that it was abuse of discretion when it determined that the testimony of witnesses was cumulative, where that testimony would have been helpful to the defendant. The testimony supported the defendant's account of the incident in several particular areas and likely would have enhanced the credibility in the eyes of the jury. I don't think there's a more on point definition or idea than that right there, because that's exactly what would have happened here. The prosecutor was permitted to argue that my client improperly influenced this witness, when in fact the testimony from this witness would have been the exact opposite. The testimony from this witness would have been that his father, my client, never talked to him about what to say to the police, what to testify to. The testimony would have been that his mother called him on the telephone and told him that he would need to say something different so that she wasn't convicted of a crime. I mean, this goes directly to the credibility of the story, and it goes directly to whether or not my client was dishonest about the assault. It goes directly to whether or not the assault actually happened, since that testimony certainly would have damaged the credibility of the prosecutor's witness and enhanced the credibility of my client. So again, I think it's clear that there is a constitutionally protected right to present a full defense, to prohibit or limit the defense from presenting witnesses that's directly responsive to something that the prosecutor introduced. It's a constitutional error. Now, hypothetically, if the prosecutor had not made those arguments or had not elicited that testimony, I think there may be a better argument to say that that's cumulative, because many of his statements did ultimately come in through other witnesses. But nobody was able to talk to the content of the conversation that he had with his mother, because only two people were present for that conversation, him and his mother. Admittedly, my client heard a portion of the conversation, but he was not present during the conversation in its entirety. So again, I think there's a constitutional error that it's cumulative. In addition to that, I would argue, I think it was an error for the judge to deviate from the non-serious misdemeanor sentencing. This is a circumstance where the judge largely relied on civil litigation between the clients, and basically openly told them, I'm tired of seeing you in court on all this litigation, so I'm going to sentence you to jail. And that's troubling. I understand that they have had a separation that has been messy, to say the least, but that's not a basis for the judge to deviate for a non-serious misdemeanor for someone who I don't believe has any criminal convictions. If he does, there's certainly not anything significant. So again, I think it was an error, an abuse of discretion for the judge to deviate there. And lastly, I would just identify again, a constitutional error, I think, warrants a de novo review. In regards to the sentencing, I suspect, or my opinion would be, I think that's an abuse of discretion review.
Thank you. Ms. Chady?
Yes, thank you, Your Honor. The people have outlined their arguments in their brief. I would just like to take a few moments to highlight some of those portions and also light of Mr. Trush's argument here today. I would direct the court to specifically look at section 2 of our law and argument section, which discusses the defendant's constitutional right to present a defense, and the case law that we've cited from both the Michigan Court of Appeals and the U.S. Supreme Court about a defendant's right to present the complete defense, but that ability does not supersede legitimate interests of the court. And that goes to the point of Judge Burmeister, the trial judge, eliminating testimony of this minor child for it being cumulative. At the point of this trial was based on evidence and events that happened on August 16th, 2023. In our argument, the prosecution did present some theories of the case about, what happened after the jury had reviewed the evidence. And in this case, the prosecution did make some comments about potential, coaching by the defendant to the minor child who was involved. However, the defendant was on trial for his actions of domestic violence and for statements that he made to law enforcement that night in their investigation. While this is a theory the prosecution presented, the defendant was not on trial based on that theory. The jury in this case reviewed lots of evidence, and that is also the basis for the trial judge's ruling of it being cumulative, because at the point that the defense wanted to call that minor child, the jury had already heard testimony from 2 officers who spoke to the minor child, and they actually saw the video itself of this assault, this alleged assault that the defendant, the appellant, had reported to law enforcement. So besides any of those other statements, let's say by the prosecution, the jury had already seen that evidence, and it was in fact, cumulative, because at the point of what the trial judge said, if he was going to testify, he would have been testifying to what the jury had already seen on that video. So in terms of it being cumulative, we would affirm our point that it was not improperly ordered to be cumulative at that point, and that in this case, whether the minor child was coached was not something the defendant needed to present a defense to. That was not one of the things he was being charged with. It was not an element of either of the crimes. And again, as Mr. Trush has already affirmed, the prosecution is allowed to argue their theories of the case. As we also outlined in our brief, multiple jury instructions about burden of proof, trial procedure were read to the jury about attorney statements not being evidence, and that they were only supposed to consider the evidence in the case. In terms of the 2 other points in section 3 and section 4 of our arguments, which discuss the sentence for this case, there is the presumption under 769.53 about a non-jail, non-probation sentence. However, that same statute does allow a trial court to deviate from that sentence if they state their reasons for that departure. In this case, the trial judge, Judge Burmeister, did mention other cases filed by the defendant because of his guilty verdict for lying to a police officer. The defendant had filed multiple cases or claims in family court, civil court, and made other cases in criminal court, other police reports about the mother/victim party in this case. The defendant has availed himself to many different cases in the court, and in this case it was found by the jury that he was lying in a serious investigation. So that is what the trial judge affirmed as being serious, because the defendant has made all of these types of claims, have brought different actions in different courts about the actions of other people, his own actions, and he was found in this case to have lied to police officers. And also what we have in our brief too is the seriousness of making false statements about someone committing a crime, and then also having our law enforcement investigate a false crime in this case. The last point in section 4 about the constitutional error and the court's analysis. The people would argue that it would be a harmless error analysis that the court would have to undergo. That would require the court to look at all of the evidence in the case. All of it is all listed, and I've briefly discussed it. We would affirm our point that even if the court here were to review all of that evidence, the jury verdict would still be the same. So with all of that, we would just affirm our point that this appeal should be denied. Thank you.
All right, thank you. Mr. Church, as the appellant, is there any response you wanted to give today?
There is, Your Honor, and again, I think there's a couple things that are important responsive to this. So I mean, the prosecutor identifies that the jury had seen a lot of witnesses, right? They'd heard a lot of testimony, they viewed some videos. What I do think is important, though, is all of that was the people's presentation of evidence. The only witness sought to be brought by the defense was this child witness. The defense ultimately didn't produce any witnesses after it was determined that the child witness could not testify, which in my mind highlights even more just how important this witness was. You know, again, I think we're constitutionally entitled to present a defense, and to suggest that that's cumulative when the only witnesses presented have been the prosecution's witnesses, I think it just more so highlights the problematic element of that. I also think, again, prosecutors make decisions in terms of how they charge a case, how they try a case, and how they argue a case. But their theories of the case become incredibly relevant to the defense. Meaning, if the prosecutor here were to have argued purely that the assault happened, but my client lied about how the assault happened, if that was the crux of their case and what they argued, again, I think maybe there's a better argument that this is cumulative. But the prosecutor chose to argue this in the alternative, that either the assault did not happen at all, or that my client lied about how it happened. This becomes relevant because it means that for the defense, we have to defend both of those claims, right? If we ignore one of those claims completely and the jury just says, well, yeah, they said that he didn't lie about how it happened, but he never addressed whether it actually happened or not, I mean, that's a problem, right? If the prosecutor chooses to argue in the alternative or chooses to argue a theory of the case that we have to respond to, again, our responses can't be cumulative. We're entitled to present a defense and to present a complete defense to all of the prosecutor's alleged claims and theories of the case. Meaning, if the prosecutor wants to limit some of that, they can do so by limiting their theory of the case, but they can't argue an expanded theory of the case and then argue that we can't be responsive to it. I think that's problematic. So again, I want to highlight that to the court. I think it's very problematic in the sense of no defense witnesses were sought. And again, the case law highlights that certainly when you're talking about defense witnesses, under the case law, it's somewhat questionable if there even can be a cumulative defense witness if it would enhance the credibility of the defendant or harm the credibility of prosecution witnesses. So again, I think that the court should and should grant our prayer for relief. Thank you.
All right, thank you. I think the parties have done a good job of outlining their arguments and the supporting law in their briefs. They certainly argued today here consistent with what was in the briefs. My missing piece is the transcript. I've been in Otsego County all week, and so I haven't been where the file is. And this isn't a criticism, but neither side attached the transcript to their briefs. Which isn't something I would have necessarily expected. But that meant that I did not have a transcript to review when I was preparing for the hearing today. I will be in Crawford County on Monday, so I'm going to get the transcript on Monday and review that. And then the court will issue a written opinion once I've had an opportunity to do that, because I think that's, given the arguments of the parties, I think that's obviously a crucial step. So the court will provide a written opinion. Mr. Shrush, as the appellant, anything further that you wanted to state for the record today?
I guess the only thing that I would indicate relative to the review of the transcripts, I'm sure the court's already aware of this, but defense is allowed to create a broader record on appeal as long as the issue is preserved. So I just highlight that because some of the arguments that we've made in the appellate record expand beyond the objections that were made at the trial.
Sure, yeah, yep, absolutely. And I'm not saying I need to review the transcripts for that purpose. Obviously, I need to see exactly what the testimony of the witnesses was as it relates to the cumulative argument in particular. So, Ms. Chady, anything further from your side today?
Nothing in terms of our, apologize, Your Honor. I did note what you stated about the transcript and being back in Crawford County on Monday. Did you want either party to try to get an electronic copy to you or do anything in terms of making sure you have that? Or are you acceptable to just, when you return to the county, reviewing the copy you have?
Yeah, I mean, since I'll be there on Monday, that's only a couple days. I think as a practical matter, I probably wouldn't be able to get to it much sooner than that anyway, so.
Okay, thank you. I just wanted to make sure you know that if you needed anything else, we could get that to you. Other than that,
Then I
nothing
do have
further.
those for you.
What's that?
I said I will have those for you.
Okay, great, thank you. Okay, that's all I have then. All parties are free to disconnect on this case today.